Good morning, and welcome to today's webcast, Bonus Credits under the Inflation Reduction Act. Before I begin, I'm going to play a brief housekeeping video.
Welcome, and thanks for joining. We're pleased to present our continuing professional education webcast series. Before we begin, please keep the following in mind. You can customize how you view our presentation and interact with the presenter. For better viewing, close all other applications and turn up your speaker volume. You can adjust window size and placement or enter full screen mode using the controls at the top right of the window or dragging the bottom right-hand corner to resize. At the bottom of your screen, you'll see a series of icons that relate to a different aspect of our session. You can download a PDF of today's slides from the Slide Deck and Handouts widget. You can ask questions by typing in the Q&A window and clicking Submit. We'll do our best to answer all questions or follow up via email. If you experience technical difficulty, refresh your browser by hitting the F5 key. Today's session offers 1 CPE credit. To receive credit, you must meet the National Association of State Boards of Accountancy requirements. You must attend at least 50 minutes of the session and respond to at least 75% of polling questions. To participate in the polls, please check the button next to your answer within the slide window and click Submit. We'll track your progress and alert you when you've earned CPE credit. You can then click the certificate icon in the CPE Progress widget and download your CPE certificate. Don't worry if you can't download your CPE certificate today. We'll email you a copy in 2 weeks. If attending this webcast in a group, you must complete our group CPE attendance sheet, available in our Slide Deck and Handouts widget to receive credit. Please have all group members sign it and send only 1 sheet per group. CPE credit can only be awarded to participants registered as themselves and isn't available for participants who view the on-demand version. This presentation is not legal, investment, or accounting advice. We encourage you to seek the counsel of a professional service provider to apply this content to your specific circumstances.
All right, I'm pleased to introduce today's presenters from Moss Adams, Ben Alderton, Senior Manager, and Liddy, Steele, Senior Manager. Ben has worked in the tax credit industry since 2012. He advises clients on new markets tax credit financing as well as other tax credit opportunities, including transferability, elective pay, and bonus credits brought on by the Inflation Reduction Act. Liddy has more than 8 years of experience in federal and state tax credit consulting. Liddy works with innovative companies from a wide range of industries to identify, increase, support, and define their R&D and IRA credit claims. With that, I'll turn it over to Ben to get us started.
Thanks, Chad. So it's great to have you all here today, and we're gonna, as obviously the presentation is talking about the tax credit enhancements that were created out of the Inflation Reduction Act, or the bonus credits, as we also call them. And I think the first thing that we wanted to talk about today is sort of what are the eligible credits, what credits came about from the Inflation Reduction Act that we're specifically targeting in terms of those bonus credits that are available. And this box is kind of a list of those credits as it relates to things like alternative fuel vehicle refueling, or EV charging stations, the production tax credit, carbon oxide sequestration, and some of the others like nuclear power production or clean hydrogen. And then as well, starting in 2025, we shift from the production tax credit of Section 45, IRC Section 45, to the clean energy production credit, which is technology neutral in, like I said, starting in 2025. And then also the same is true with the investment tax credit. And then additionally, there's the other one that's not sort of in these normal sections that I think about, just because I work with the ITC and the PTC most of the time, is the energy efficient commercial buildings deduction under 179B, where you can claim a bonus deduction based on meeting certain prevailing wage and apprenticeship requirements within that code section as well. We thought it would also be helpful to kind of level set a little bit as to what we're talking about as far as the different enhancements or bonus credits that are available. And these next two slides, we'll talk about each of these as we go through the presentation. Liddy's going to start and spend the bulk of our time with the prevailing wage and apprenticeship requirements. And then that credit qualifies you for a 5 times multiplier off of the base credit. So the IRA took all the investment tax credits, and which is an investment tax credit, I should explain, is a credit based on the placing applicable energy property into service. So if you think about a solar array on top of a building, it is the structure and the solar panels and the costs that are associated with that, versus the production tax credit, which is based on the amount of energy or widgets that are produced and qualified under the IRA. So the base credit can be multiplied by 5 times to get to a 30% credit if you meet the prevailing wage and apprenticeship requirements. The next one we're going to talk about would be domestic content, and that's your Buy USA provisions, essentially. Then the next one that can be stacked on top is energy community. Most of the energy community bonus is pretty well location based. It can also, we'll talk about the fact that it can also be based on certain environmental contaminations that might or might not be present on a given site. And then the last two are the environmental justice allocation. These last two would theoretically get you from up to a 60 or even a 70% total bonus credit if you were to qualify for each and every one of them. But the last two, and we'll talk about that, are based on an application and being allocated a portion of the available enhancements that exist. This is the same slide essentially for the production tax credit. You'll notice there's no environmental justice allocation associated with it, but we have the same prevailing wage and apprenticeship requirements giving you that 5 times multiplier, and then the domestic content and energy community adders that we're going to talk about as we move through things. So hopefully that kind of helps level set what we're going to talk about a little bit, and I'm going to transition it over to Liddy to talk about the prevailing wage and apprenticeship requirements.
Thanks, Ben. So as you mentioned, we'll be starting today with the prevailing wage and apprenticeship credit enhancement and spending most of our time discussing that enhancement because it offers, well, the most substantial increase to credit benefit, but also has the broadest application to projects eligible for the IRA credits because it doesn't have some of those site-specific limitations that Ben just mentioned. And it's the only enhancement that can be fully cured if a taxpayer initially fails to meet the requirements, so they can retain that enhanced credit. Or the other enhancements, if you fail to meet the requirements, that's sort of the end of the story. So, perhaps because of the significant benefit and the broad application for the PWA enhancement, it does also have what are arguably the most complex requirements, including documentation to receive that enhancement. So we'll be talking a little bit about those requirements, documentation, administrative hurdles in our presentation today. So getting us started, high level, as Ben mentioned, it's a 5 times multiplier on the ITC or PTC credits. The intent is to ensure that all laborers on a job are being paid a prevailing wage and to encourage the use of apprentices. This is all with the objective of creating a stronger economy and creating jobs. Right away, I just want to note that the definition of laborer is anyone whose duties are manual or physical in nature, including the use of tools and equipment. So it's not going to include your engineers, your site supervisors. It really is those that are engaged in that manual labor. These rules apply to IRA credits for projects beginning construction after January 28th, 2023. And for those with a maximum net output of greater than 1 megawatt. So if you either started construction before that date or you have a smaller project, you're going to be grandfathered in and you will not have to the enhanced credits and you won't have to meet these requirements. So, but before I get too far into the details, wanted to get a sense of sort of what the audience wanted to get out of this presentation. So with that, I'm going to kick it to Chad for our first polling question.
Awesome. Thanks, Liddy. And we have our first polling question of the day. How familiar are you with the prevailing wage and apprenticeship requirements? A, B, somewhat, I'm familiar with the overall requirements, but not sure how they actually apply. C, not ready. I've heard of a PWA requirements, but don't know anything else about it. Or D, not at all, starting from the beginning. So we'll give you about 20 to 30 seconds here to answer this polling question. If you just select your answer and hit the submit button, it will be recorded. All right, we're just about at 80%. So we'll give you about another 5 to 10 seconds here to answer the question.
And I think the answer for A was supposed to be, I'm just here for the CPE, and that's a totally acceptable and honest answer if that's the case.
All righty, gonna move on to the results here.
Okay. All right, so it looks like a pretty even split as far as people's familiarity. So I'll try to kind of cover the baseline for all of those that aren't familiar with PWA requirements, but also get into sort of what we view as some of the key points of the rules, particularly some proposed guidance that was recently issued for those of you that are seeking sort of more detailed guidance as to how to apply these rules for your projects. So addressing first, what are the requirements? It's a and statement. So just to be clear, you have to meet both the prevailing wage and the apprenticeship requirement. You can't meet one and not the other and still qualify for the enhanced credit. So addressing first, prevailing wage. Laborers must be paid the applicable prevailing wage based on the county, construction type, and activity performed. That applicable prevailing wage is determined by the Department of Labor. You can find it on their website, sam.gov. Go to the wage determinations link. And within there, you're going to identify state, county, and construction type. For most IRA projects, the construction type is going to be heavy if it relates to kind of mechanical facilities and equipment, but it may also include the construction type building if it includes areas where the operators, those working in the facility, are going to be housed. And then I also want to emphasize that it's based on the activity performed by the laborers, not their job title or qualifications. So that's going to get to kind of the granular documentation and tracking component of this. You're tracking, what were the laborers paid, but also what were they doing, hour by hour, day by day, as in the form of activities, and do the wages paid while they're performing those activities meet the prevailing wage requirement. So shifting over to the apprenticeship piece, there are 3 parts. The first 2 are interrelated, and that is that you have to engage apprentices for a minimum percentage of the total labor hours on your project. Beginning in 2024, that minimum percentage is 15%. If you have a project that started construction in 2023, that percentage is 12.5%. Related to that requirement, there is the apprentice to journey worker ratio. So in order for your apprentices to qualify towards that labor hours percentage, they have to be enrolled in a registered apprenticeship program. And part of that registered apprenticeship program is it's going to define the acceptable apprentice to journey worker ratio. There are also standards set by the Department of Labor and state, and those standards would need to be met for your program to be approved. And so that ratio, it could be 3 apprentices per journey worker, let's say for electrical work. And what that means is if you were to have 4 apprentices and 1 journey worker on the job site for that particular day, that 4th apprentice, who's in excess of the 3-to-1 ratio, their hours would not qualify towards your labor hours percentage requirement. They would essentially be considered a non-qualified apprentice. And so I want to pivot back real quickly to the other note there on prevailing wage, that for qualified apprentices, they can be paid below the prevailing wage rate. It'll be a percentage of the prevailing wage rate as defined by their registered apprenticeship program. But if they are not a qualified apprentice because they're in excess of that apprentice to journey worker ratio, then they have to be paid the full prevailing wage rate. So there could be a scenario where if you're not keeping an eye on that ratio, you're failing to meet both the apprenticeship requirement and the prevailing wage requirement because you have a apprentice whose hours don't count towards your percentage and they aren't being paid the prevailing wage. So keeping an eye on that ratio is going to be key. A third component, which is actually separate and distinct from the first 2, is the apprenticeship participation requirement, which is any taxpayer, contractor, or subcontractor who employs 4 or more laborers on the job must employ at least 1 qualified apprentice. If you don't do so, there will be penalties associated with the work that should have been performed by that apprentice. So I just mentioned penalties, so this is a great segue into our next slide, which is what are those penalties? For the prevailing wage requirement, it's $5,000 per laborer that is paid less than prevailing wage, plus the difference between what they were paid on prevailing wage in the form of essentially back pay and interest on that back pay. You have to make the laborer whole and as if they were paid the prevailing wage at that time. If the IRS feels that a taxpayer willfully disregarded these requirements and is still pursuing the enhanced credit, the penalty actually increases to $10,000 per labor if it's deemed willful disregard. On the apprenticeship side, the penalties are $50 per hour, by which you do not meet the labor hour percentage, and then also $50 per hour by which the apprenticeship participation requirement is not met. That was that one where if a contractor has 4 or more laborers, they have to employ at least 1 apprentice. How those hours penalties are determined is you take the total labor hours performed by that contractor's laborers, divide it by the number of laborers, and then whatever that number of hours is multiplied by $50 is your penalty there. Again, there's a enhanced willfulness credit or penalty, if the IRS deems that you are willfully disregarding this requirement, as in you did not show an attempt to engage apprentices on your project. And that enhanced penalty is $500 per hour. And that applies to both the penalty under the labor hour percentage requirement as well as the apprenticeship participation requirement. And so with that, we're going to jump to our next polling question to make sure that we get you enough polling questions for CPE credit. Chad?
Thanks, Liddy. Who is responsible for paying the PWA penalties to the IRS? A, contractor, subcontractor who didn't pay their laborers a prevailing wage or use enough apprentices. B, project owner. C, taxpayer that buys the credit if transferable. D, either A or B, depending on the purchase agreement. So if you select your answer and hit the submit button, it'll be recorded today, and we'll give you about 20 seconds here to answer this polling question.
As we're waiting for these answers to come in, a question did come in regarding the exception, the 1 megawatt or less exception to not meet the PWA requirements, and whether or not that was measured in alternating current or direct current or AC or DC. And the code is clear that it's measured in AC or alternating current.
And I'll also go ahead and address the question regarding shortage of apprentices. In some of the labor categories, again, looking at the type of activities performed on these projects, we have been hearing there is a shortage of apprentices. There are a lot of contractors, subcontractors that are registering their own apprenticeship programs. So that is an option that's available to you. Register your own apprenticeship program, and that way you can ensure that you have apprentices on your job because they are your own. But otherwise, yes, going out and seeking apprentices through a third-party apprenticeship program can be difficult at times. There are, we'll get into a little bit later, but there are provisions in the rules that grant you sort of good faith exceptions if you do, in fact, put in that effort and you just cannot find apprentices for your job.
Great. We'll move on to the results here.
Okay, so I think the trick in this question was to the IRS, because there certainly could be a trickle down of liability through contracts. So the answer is actually the project owner, so the original taxpayer who is, performing these activities, engaging in this project that qualifies for the IRA credit. They are responsible for paying the penalties. If ultimately they sell their credit, because many of these credits are transferable, the buyer is not liable for the penalties. However, if those penalties are not paid, they may not have a credit that will be acknowledged by the IRS. So that's where, a lot of this, as far as the level of detail, monitoring and administration to ensure you meet the PWA requirements, may depend on if you do intend to sell your credit, if you already have a buyer lined up, what their requirements may be. So if you are thinking that you will be selling your credits, please start looking into that, ideally before you start construction, so you know kind of what the expectations are as far as documentation and support for that credit. Ultimately, yes, it seems like the contractor and subcontractor who was informed of these rules and just did not follow them should be the responsible party and pay those penalties. But they're not going to be responsible in the eyes of the IRS. It's up to you and your team of lawyers to hold them responsible through your contract language. So again, I think looking to that pre-construction and making sure that you have some of those protections in place in your contracts is going to be key. So I mentioned that there were some proposed rules, 2 sets, in fact, one that was issued start of September and one that was issued actually just recently, a few weeks ago. The proposed rules at the start of September did provide some guidance as to prevailing wage. One of those was, well, what if the prevailing wage rate set by the Department of Labor changes during the course of my project? My project is scheduled for, 4 years between start and end of construction. It's the prevailing wage rate as of the start of construction. So again, when you're looking at your contract agreements, I think checking the applicable prevailing wage rates when you're setting those budgets will be important, but you're also going to need to check those applicable prevailing wage rates as of the start of construction, which is a technically determined date. And those are going to be the wage rates that apply for the course of your project, with the exception of if you go significantly, if you add to your scope of work, then it will be a new prevailing wage rate for that additional scope of work as of the start of construction for that addition. Or if you go significantly past your originally proposed timeline, then the prevailing wage rate will sort of start again once you're past your originally scheduled completion date. So as I mentioned before, the prevailing wage rate does still apply to apprentices. It's based off of the percentage of prevailing wage rate as determined in the registered apprenticeship program. And that percentage is going to need to be approved by either your state apprenticeship agency or the Department of Labor's apprenticeship department. If One of the concerns early on was there was a scenario in which you would not be able to cure if you had a laborer that was not paid a prevailing wage, and they could not be located to pay them that back pay and interest. I think something to note here is that labor does not equal employee. So there could be a scenario where you are hiring temporary laborers, day laborers, that if down the line it's determined they weren't paid a prevailing wage, could be difficult to track down. In the proposed rules, there is now a remedy to still effectively cure if that's the case, and it's the taxpayer can utilize the state's unclaimed wage or unclaimed property program, put that back pay and interest into that program with whatever identifying information you have for that labor. This is, of course, after you actually make a good faith effort to locate that labor. But if you can demonstrate that you've made that good faith effort and put those funds into the state unclaimed wage program, then you have effectively cured and can retain your eligibility for the enhanced credit. There's also, I think this is kind of the biggest piece and biggest incentive to proactively monitor for prevailing wage and apprenticeship compliance, is there's now an opportunity to have the penalties, that $5,000 penalty per laborer, waived if you correct any errors in prevailing wage by the earlier 30 days from the date it's discovered or before the tax return is filed. The laborer was not paid below the prevailing wage more than 10% of the time, or that deficit in wage is not greater than 2.5% of the prevailing wage rate. Or if you engaged in a pre-hire project labor agreement that clearly incorporated the prevailing wage and apprenticeship requirements. There's a whole subset of requirements for what would need to be incorporated in that labor agreement. But if you utilize that project labor agreement for your project, then you could also receive a waiver of penalties from the IRS. It is a discretionary waiver, but it does incentivize, again, that proactive monitoring and compliance piece. On the apprenticeship side, again, there's a potential penalty waiver if you use a pre-hire project labor agreement. It also kind of offered further criteria to meet that good faith effort exemption that I mentioned during our break for the polling question. And you would not have to pay a penalty for failing to meet the apprenticeship requirement if you show that good faith effort. Now, this would only be as to the specific hours by which you tried to obtain an apprentice. So if you need 4 apprentices to meet the requirements and you obtain 3, then as far as that, you're only going to get a waiver of penalties regarding that 1 apprentice that you tried to obtain and could not obtain. If the other 3 still fail to meet the requirement, then you may still have hourly penalties related to the other 3 apprentices. To qualify for the good faith exception, you may be required to apply to more than 1 apprenticeship program if multiple programs are available to you based on the geographic area of your site location and the activities those apprentices will be performing. And even if you apply to an apprenticeship program and they either do not have an apprentice that's available to you or do not respond, you will have to resubmit that request at least every 120 days to maintain the exception. So it does give an option where there may not be apprentices available, but there is going to be an administrative burden there to maintain your eligibility for that good faith effort exception to the penalties. Some additional pieces included in those proposed rules was, I mentioned those enhanced willfulness penalties, $10,000 for prevailing wage, $500 per hour for the apprenticeship requirement. If avoid those increased penalties, you can create a presumption of unwillfulness by meeting several criteria. It's a facts and circumstances test, but 3 of the significant facts or circumstances that you could meet is including it in your contractual agreements, posting signs on the job site defining the prevailing wage rates and apprenticeship hours requirements, apprenticeship ratio requirements, and then reviewing at least quarterly, if not more frequently, for PWA compliance. So again, they're really trying to encourage, by the possibility of waiver or protection from penalties or enhanced penalties, that proactive compliance and monitoring piece. Another key piece of guidance that came from the proposed rules was addressing secondary construction sites. Many IRA eligible projects are in remote locations where there may be a portion of the work being constructed at a secondary site and then transported to the final installation site. And if that's the case, you could have a second set of prevailing wage criteria that would need to be met, because you also have to be meeting the PWA requirements at that second site. So if it's a different county, if you're doing different work activities at that site, you could have additional prevailing wage or secondary prevailing wage criteria for work performed at that site. Now, what requires you to meet prevailing wage and apprenticeship requirements for a secondary site is if a significant portion of a building or work is constructed at the secondary site for specific use in the qualified facility. So this is intended to exclude a wind turbine that is manufactured at a different site, transported to and installed. That manufacturing site for wind turbines, because they're likely manufacturing turbines for other projects, other installations, is not a dedicated facility. So it's not going to be considered a secondary site. And also, is that site established specifically for the performance of the covered contractor project or dedicated exclusively to the covered contractor project? So again, if it's an existing manufacturing site or preparation location, it's likely not going to be considered secondary. This would be more if you kind of rented a warehouse that was closer to a city or transportation hub where you could do some of the initial manufacturing and assembly of equipment and components for the construction site, and then ship those out to the construction site. But you had rented that warehouse, outfitted that warehouse specifically for the purpose of that project being constructed at the primary site. And so, I've mentioned some of these, but in complying with these rules, big administrative hurdles that we're seeing right now is sufficient contractual provisions, and this is through all tiers of ownership and management on a project. So starting with the project owner and your primary contractor, and then between the contractor and all subcontractors and subs of subcontractors, ensuring that the contractual provisions are flowing all the way down, because any laborer on the project is going to need to meet these requirements. Within that is negotiating liability for penalties. We've seen all different forms. Some have no language. Some hold the primary contractor responsible. Some hold the subcontractor responsible. Again, that's between you and your team of lawyers and the contractors and subcontractors you're negotiating with. And then making sure that you include a documentation piece in that contract language as well, because it's not just are they complying with it, but are they going to provide you with sufficient documentation that you can show compliance if this is reviewed under exam by the IRS. So making sure that you have some documentation language in there where they're going to cooperate with that effort to retain and gather the information necessary for a defense under exam. Another piece is supplemental wage determination. So what do you do if the activity that's being performed isn't really captured in the current Department of Labor prevailing wage reports? Currently, the claim is that, well, all activities should be captured. They feel like they've pretty broadly covered this. But we're already kind of seeing some very nuanced and technical subspecialties on these projects that, particularly kind of in the electrical field, but they are not electricians. And so determining when you need a supplemental wage determination, this is where you go to the Department of Labor, you describe the activity being performed, you offer them what you feel is a reasonable wage rate to receive for that, and then they agree or they offer you their own determination as to reasonable wage rate. So when to seek those. Again, registered apprenticeship programs, either utilizing existing programs, creating your own, getting approval for those programs. We are seeing some inconsistency between Department of Labor requirements and state agencies and who is managing that piece. And then also, because again, we're dealing with sometimes, highly specific technical specialties, reciprocity between states. You have a registered apprenticeship program in one state, but your project is being performed in another. And ensuring that your apprentices are going to get credit towards their apprenticeship program and be considered qualified apprentices for the work performed in that other state. There is supposed to be reciprocity between states on that, but getting the sign off of both states on that reciprocity agreement can be administratively challenging. And then the last piece is just the compliance monitoring. That's kind of the maintenance piece during active construction. How frequently are you going to do it? Again, the IRS would like to see quarterly, if not more frequently. That's going to protect you against that presumption of unwillfulness. If you do proactively monitor and catch any incidents of noncompliance with the requirements, you could avoid some penalties. But the question there is kind of how in depth do you need to go? How much can you rely on the information being provided by your contractor or subcontractor that it is accurate and complete? Again, that's all going to be kind of project specific and project owner specific, but things to consider. So with that, I'll kick it back to Chad for another polling question. And then I think we're going to switch over to Ben after that.
Awesome. Thanks, Liddy. And we have our third polling question of the day. Have you or your clients incorporated PWA provisions into your construction contracts? A, yes. B, no, but will start. Or C, not applicable. So again, if you just select your answer and hit the submit button, polling question will be recorded. We'll give you about 20 seconds here to answer this polling question.
Hey, Liddy, one of the questions that came in was if we had examples of apprenticeship programs, and I'm thinking about like a county apprenticeship, a county might have it, or a state might have an apprenticeship program. Are there other examples you know of that would be like example apprenticeship programs?
Yes, counties and states sometimes have their own programs. Where we see it a lot is actually kind of community college-based programs, where they're creating those technical jobs programs. So that's a great place to look. But your state should have a list or registry of all of their current registered approved apprenticeship programs, and specifically the trade for those programs. If you look at that, a lot of them will be private entities. These are companies that have decided to create their own apprenticeship programs, but some of those are more of the kind of schools, the community colleges, the counties, where you can go to them and request apprentices for your job.
Awesome. Moving on to the results here.
Okay. Well, good for that 12%. You guys are ahead of the game. For those that haven't, but you're going to start, I think hopefully you're not under construction. If you are, I hope you have a great relationship with your contractors and subcontractors. Most of them seem to be, kind of willing to cooperate because they understand the importance to you. And I mean, this is kind of the nature of the market is headed. So the quicker they can get on board with those monitoring and documentation requirements, the more marketable their services are going to be. And for those that are not applicable, I'm assuming you guys might be falling into the I'm here for the CPE crowd, or you're in a related professional services field.
All right, I think I'm going to take over now. I went too far here. Take over now and talk about some of the other credit enhancements that we talked about back at the very beginning, and specifically the domestic content, the energy community, and the environmental justice allocation. And so as Liddy indicated, there's a lot more in-depth rules and regulations as it relates to the PWA requirements, and the others are not quite as in-depth, or especially as it relates to the domestic content percentage. There's a lot of there was one round of regulations that was issued by the IRS, and the consensus is in the industry is we'd sure like to see more, because I think it really created as many questions as it answered, if nothing else. So I do think there might be some additional regulations that come out as it relates to domestic content. But that bonus is a 10% bonus, as we talked about. You can actually still get a bonus if you don't meet the prevailing wage and apprenticeship requirements, but it's reduced substantially down to 2%. So you lose your 5 times multiplier that you would have received for getting the 6% to the 30%. You also lose the 5 times multiplier and get 2%. So, or you're exempt, and the exemptions as well is for less than 1 megawatt in size. And then, so this is, as I indicated before, the Buy America program. So it's 100% of the steel or iron that goes into the facility needs to be produced in the United States. And then it starts out as 40% of manufactured products need to be manufactured in the United States. It starts out at 40% for projects that begin construction through the end of 2024. And then it increases annually each year. And I think it's 2027, the number jumps to 55%. So it does account for the fact that right now, maybe it's a little more difficult to meet domestic content, so that and especially as it relates to the manufactured product. And so it's at 40% now and ratchets up as we go along. Additionally, you are seeing a lot more manufacturers, because of the 45X green energy manufacturing credit, that you are seeing a lot more opportunity to probably purchase these the manufactured products in the near future, hopefully in the near future. Then the other consideration to think about here is related to the direct pay bonus. And so starting in 2024, if you do not meet, and you're over 1 megawatt in size, so you do have to be a larger project over 1 megawatt in size, you actually can suffer a reduced credit percentage if you do not meet the domestic content requirements. There is an exception that you can apply for. You basically ask the IRS to waive that requirement for you, but in order to get it, you need to demonstrate that for some reason you cannot meet domestic content. Maybe it's just not available. It's just not. I think there is a provision in there related to the economics as well, that it is not worth. The economics are such that you really just can't meet the domestic content requirements. So some key considerations that we've alluded to already on some of this is the need to plan early. So just like with the prevailing wage and apprenticeship requirements that we talked about, building this language into your contract agreements and your supplier agreements early on in the process is important, and the opportunity to be able to verify and understand where the various components came from that you're installing, so that you can, if the IRS comes back later, you can say, yes, IRS, we can prove. Here's what we did, and here's the calculation essentially that shows us that we met our domestic content requirements. So you do need to plan early. And right now there is no cure provision. So if you are at 49% of your manufactured, or 39% of your manufactured products, you're not going to meet it. You can't cure when you do the calculation. So it is important to plan early. And you do need some certification from your suppliers and ideally a right to go in and take a look at some of that backup documentation so that you can, like I said, demonstrate to the IRS that you're meeting the domestic content requirements. On the manufacturing side, we're seeing manufacturers that are actually getting ahead of this idea, thinking, well, our product is manufactured in the United States. We're willing to demonstrate that. We're willing to show that. And we think, I personally think there's a competitive advantage to that, in that these manufacturers are ahead of the game. They're helping projects to demonstrate that if you utilize my solar inverter, for example, you're going to be on your way to meeting domestic content versus if you use one of my competitors out there. So something to consider, that a competitive advantage may actually exist on the manufacturing side. All right, the next enhancement is related to the energy community. So as I indicated, this is a 10% bonus, and it's usually, we think of this as really location-based. You're either in an energy community when you start construction or you're not. And it is measured at the start of construction. And there's 3 ways that you can qualify for being located in an energy community. The first way is in the brownfield category. So a project can be located in a brownfield, and that can be a federal, state, or even a tribally designated brownfield. And that would qualify for the 10% bonus. Additionally, for facilities that are greater than 5 megawatts in size, and there's been a phase 2 environmental site assessment performed that confirms there is actually contamination or pollutants, then that would qualify as the brownfield category, meeting the brownfield category. If you're less than 5 megawatts in size, so it's much smaller facilities, if a phase 1 has been performed, a phase 1 environmental site assessment, and it just identifies the potential for the hazardous substance to exist, then you can be considered located within an energy community. The next 2 ways are actually ways that we can just pull up a mapping tool. The Department of Energy has developed a mapping tool that gives you the initial look to say, yeah, we're in an energy community or not. And then as well, they've published specific census tract data that you can then reference, and that is more authoritative than just the mapping tool. But those 2 categories are the statistical area category, and it depends on being located in a metropolitan statistical area, or if you're in a non-metropolitan or rural area that has had fossil fuel employment that meets certain thresholds, and that MSA or non-MSA has an unemployment rate at or above the national average. And that it's important to note that you have to meet both of those requirements. And the unemployment data is actually tested each year. So the IRS, the regulations or the proposed regulations that the IRS has issued, has indicated that they're going to update each year the MSAs and non-MSAs that meet the requirements for energy community. And it's based on the unemployment data that's released usually every April. And so when the unemployment data came out this year in April, it took a couple of months, or it took about a month, roughly maybe 6 weeks, before the IRS was updated their mapping tool, or the Department of Energy updated their mapping tool, and you could actually tell whether or not you were located in an energy community. And then the next one is coal closure category. So this is census tracts or adjoining census tracts that has either had a coal mine or a coal-fired electric generating unit that's been decommissioned after 2009. And again, this is something that you can map and determine whether or not you're in that coal closure community. It shows it very clearly on the Department of Energy's map, and there's a link to that map there. And that will enable you to at least get that first initial look, and then you can look at whether or not that census tract is actually listed as one of the one of the qualifying census tracts. What's important is there is a safe harbor that exists. So the IRS did indicate that there is a safe harbor. If you're located in an energy community at the beginning of construction, then you are deemed to be in an energy community for the remainder of the credit period. And this is important because, as we indicated, if you're qualifying based on the fossil fuel employment, the unemployment rate, as I said, will change every April. And if you have a production tax credit that has a 10-year stream of credits that's associated with it, you would sure like to know that you're going to be in an energy community for the entire 10 years. And so the IRS did indicate this safe harbor does exist. The next enhancements are the ones we talked about earlier, and I mentioned earlier that these, the environmental justice allocation is an enhancement that is the one that you don't kind of get as of right. If you are located within an energy community, you can get the bonus. If you meet the requirements for PWA and domestic content, you get the bonus. The environmental justice allocation is the one you actually have to apply for. And so there's 1.8 gigawatts of allocation authority that's issued every year, and it qualifies for an either a 10% or 20% bonus, depending on which one you apply for. And so those categories are listed there as a low-income community or tribal land. So if a project is located in a low-income community, which is based on New Market Census Tract data, or on tribal land, then you can apply for a 10% allocation. You're not guaranteed that. You do have to make an application, and you do have to meet all of those other requirements within that application, and then be awarded a portion of the allocation authority. And it's also important to note that you have to choose which category you're going to try to fall into. So if you are located on tribal land, and it is also designated as a low-income community, you have to choose which one of those allocation capacity limitations you want to apply for. Do you want to look at the tribal land, or do you want to go for the low-income community? Because the capacity, there is a lot more capacity that's allocated to the low-income community, but maybe there's more applications as opposed to then on tribal land. You have to kind of make that evaluation yourself. And then the next two are related to affordable housing or community benefits, where the benefit, if for example, solar is located on or adjacent to and it benefits an affordable housing project, you can apply for a 20% bonus credit associated with that. Additionally, if more than 50% of the financial benefit of the power that is being generated goes to low-income persons, then as well you can qualify for it and apply for that 20% bonus credit as well. A couple of things that you have to consider is that you cannot place the project in service prior to the award. So this is designed to this bonus is designed to bring new entrants is designed to help projects that may or may not normally get completed in some of these areas that have suffered from less green energy investment than others. And so placing it in service prior to the award, the IRS is deemed as contrary to what the intent of the statute is. And then the 2023, this slide is a little bit old in the fact that the 2023 applications actually did open in October, and the initial 30-day period closed on November 19th. Now, if you did not make that November 19th deadline, they do accept applications on a rolling basis thereafter, and it's based on the amount of capacity. But there's only so much capacity that can be sort of doled out, and if it's all gone, unfortunately, then it's lost at that point. Your application, you'd have to wait till 2024 to apply. There is a question that came in for what is MFI, and 8 on my slide there, and that's a great question, and that is median family income. So it's less than 200% of the poverty line, or households with less than 80% of the area median family income, which can be determined based on the census tract information. All right, so this is a repeat of the slide that we started out with early on, showing how everything sort of stacks up. And as we're running out of time, I'm just going to go through this quickly. And there was a question that came in asking if the bonuses are capped on the 5 megawatt or not. And the answer to that is as it relates to PWA, domestic content, and energy community, that can be for any project that qualifies. So if you have a large utility scale solar that's located in an energy community, it can receive that 10% energy community bonus. The environmental justice allocation is for projects that are under 5 megawatts in size. Only those projects that are under 5 megawatts can qualify for the environmental justice allocation. And so as we indicated before, you step up the ladder here, and if the project were to meet all of the requirements, let's say that it's a 1 megawatt development that meets prevailing wage and apprenticeship requirements, meets domestic content, is located on an energy community, and also benefits, is also associated with an affordable housing complex, then you would qualify for, and you receive that allocation for the environmental justice allocation, you would qualify for a 70% credit percentage. And this next slide I'm going to skip over this next one in the interest of time. And this next slide kind of shows a few examples as it relates to that. So the first example there is one that meets all of the various requirements of, say, rooftop solar, less than a megawatt in size, or even if it's less, it should be less than 5 megawatts in size. Costs $5 million in theoretical costs here, but you qualify for each of the various credit percentages. The credit earned in that situation would be $3.5 million, based on your qualified $5 million of costs. And then if we talk about a large microgrid battery storage interconnection project on the next one that just meets the prevailing wage, domestic content, energy community, you qualify for that 50% bonus or $10 million credit on your $20 million of project costs. With that, I think, Chad, we are now at the last polling question.
All right. Thank you, Ben. We'll kind of advance here to the fourth polling question. And I'd like to learn more about A, prevailing wage and apprenticeship requirements, B, domestic content requirements, C, other tax credit enhancements, or D, I'm just here for CPE. So we'll give you about 20 seconds to answer this one.
I think we've tried to answer everybody's questions as we went along, and tried to make sure that all the questions in the Q&A boxes were answered. To the extent you have any additional questions, feel free to put them in the Q&A box now, and we'll get back to you. Or I know on the next slide here, when we get to this last slide, we do have our contact information. You can feel free to reach out, and we'll be happy to. Liddy and I will be happy to try to answer your question, shall we say. So.
All right, we'll give about 5 more seconds here to answer this one. All right, going to move on to the results.
The results, most people are here for the CPE. I understand, I get it. So we appreciate you being honest about that. And those of you that would like to learn some more, we can feel free to obviously reach out to us, or we can follow up after the webcast at a later date. So there's Liddy and I's contact information, and I know, Chad, you're going to talk about the fact that you can download the slides, and there's a survey.
Awesome. Thank you, Ben and Liddy, for a great presentation today. If we didn't have time to answer your questions, we'll do our best to follow up with you after the webcast. As a reminder, if you attended today's presentation in a group and would like to receive CPE credit, you must complete the group attendance sheet found in the slide deck and handouts window. If you participated as an individual and met all certification requirements, your certification is available for download now in the CPE progress window. I'll keep the webcast open for a few minutes to give you time to download your CPE certificate. A copy of your CPE certificate will be emailed within 3 weeks should you have any difficulty downloading it now. And here is a link to an online survey where you can provide feedback for today's presentation. Please take a moment to complete this, as your feedback is very important to us. Thanks for joining us today, and we hope you'll join us again next time.